pleasure in welcoming our eminent panelists and our audience today for this thematic discussion on the three new criminal codes. And just in advance, I would like to tell you that this is being recorded and Live Law and our YouTube channel is live streaming it. So I thought you should have advance notice. Our intention in having this panel is to make the audience reflect on the nuances of the new laws through specific themes. And underlying these themes are significant questions that the introduction of these laws raise. And I just want to highlight two to start off this discussion. First, about decolonization as a reason for new laws. And second, about the relationship between the state and the individual in the exercise of coercive power. We all know that it is not the first time that criminal laws have been revised in this country. The last time in 1973, I think it took 6 law commissions and over more than a decade for the 1973 CRPC to be brought in. And the motivation then was also to Indianize these laws. But the justification of the laws introduced this year to decolonize criminal laws, we might say, is similar. However, decolonization is too broad a concept to give us any normative grasp on what we should do. Colonialism is both a historical and economic concept based on arrangements that led to impoverishment and oppression. But the colonial era was so expansive in time and space that it included varied thinking about various forms of human affairs. Therefore, it might be wise to look specifically on the products of colonialism through some specific concepts such as oppression, impoverishment, and discrimination, and decolonize in those specific senses. Our panel today would help us think through the motivations for these laws, amongst other things. The second point, which I thought perhaps is something that we can all reflect on, is criminal law in India has seen at least 2 big waves in the last 3 decades. And one is the advent of special criminal laws, and that have come at the expense of individual liberty as they carved out exceptions to the questions of procedure, bail, and imprisonment. The second is these new set of criminal laws. And even if it is interesting that the law itself does not provide many resources to think about what should be criminalized and how much one should be punished, it does bear upon a larger question of how the state or individuals can justify their use of coercive power over others. As such, traditions in the law do bring into focus the interaction between coercive power and liberty, with the developments in law traditionally being tools seeking justification for the exercise of coercive powers. Do our new laws speak to those arrangements, or those traditions in law is something for us to think about? I'm sure that the discussion that will follow will help us think about both the specific and general issues about the 3 new codes. And with that, let me first introduce our moderator for today's discussion, Professor Shraddha Chaudhary. Professor Chaudhary is an assistant professor at BML Munjal University. Her areas of interest are criminal law, family law, the intersection of law with feminism, and the treatment of women and children in the Indian criminal justice system. She has previously taught at O.P. Jindal University and National Law School, Bangalore, and she has also worked on several projects on the rights of children and juvenile justice. She received the Cambridge International Scholarship and Rajiv Gandhi Cambridge Scholarship for her LLM and PhD at the University of Cambridge, and is also an alumna of National Law School, Bangalore. I will now hand it over to Professor Chaudhary to start the panel discussion and also introduce our panelists. And we will be having some audience trickling in, so those who are here, we can perhaps be in the front, and the others can take the back seats. So over to you, Shraddha.
Thank you, Preetham. Welcome everyone, and thank you for giving us your time on a Saturday. Hopefully you'll find by the end of it that it was well worth it. As I'm sure we're all aware, Indian criminal law is in a stage of transition. We might say it's in a stage of upheaval, even of flux. The Indian Penal Code, the Criminal Procedure Code, the Indian Evidence Act, these have been our criminal laws for several decades now. We're all familiar with these laws, with these names. And it isn't as though these particular statutes had never undergone amendment. Like Preetham just told us, the Criminal Procedure Code at least was completely amended and reenacted with the very same purposes that we hear about these 3 new laws. But this time, we are told the laws haven't merely been amended or tweaked, they have been overhauled. Completely new statutes have been enacted. And that's exactly the point. This is what we are told. The new laws are purportedly an exercise in decolonizing Indian criminal law, bringing it into the 21st century with a heavy focus on digitalization and electronic evidence and all that sort of thing. And so the narrative around this is that we are moving from what was a penal or punishment oriented approach to a new justice focused one. So we'll be examining exactly this today, what we are told and what is the truth of the matter. And hopefully we'll get to the bottom of that, critically assess the changes, test their credentials, see whether they actually usher in a decolonized and justice-focused approach, and appreciate any changes that seem positive, question the changes that seem problematic, and consider any opportunities that might have been missed in what was undoubtedly a massive overhaul exercise. To do this, we've put together a highly experienced expert panel, as you can see, and I will introduce each of them as their panels come forth. In order of their panels, we have Dr. Mrinal Satish, Dr. Anup Surendranath, Ms. Rebecca John, and Mr. Sanjoy Ghose. I will, as I said, give more detailed introductions as their panels come through, but we all know that they are really wonderful, nice people who've given us their time on a Saturday to educate us. So I think we can all agree on that to begin with. Right, so leading the discussion on our first panel today, the changes to substantive offenses, we have Dr. Mrinal Satish. Dr. Satish is currently a professor at the National Law School of India University, Bangalore, where he teaches criminal law, criminal procedure, among other subjects. He has previously been a faculty member at the National Law University, Delhi, and the National Judicial Academy, Bhopal. He has published a wide range of empirical and theoretical research on substantive criminal law, punishments, and the functioning of the criminal justice system. Aside from teaching and research, he has also participated in some of India's foremost law reform efforts, having assisted the Justice Verma Committee, been part of the subcommittee drafting the report on the 262nd Law Commission report on death penalty, and made recommendations to the Parliamentary Standing Committee on the Surrogacy Regulation Bill 2016. Welcome, Mrinal, and over to you for the first panel.
All right, that's fine. Anywhere, wherever you are. Okay. If everyone can see me, then I'll sit here. Okay. Thank you, Shraddha, and thank you, Preetham, for inviting me here. So as both Preetham and Shraddha spoke about sort of the motivations behind the law and attempt to critique it, that's exactly what I'm going to try and do it for 15 minutes, Shraddha. Is the time? Yeah, so I have a clock in front of me, so I keep an eye on that. Okay, so again, as Preetham mentioned initially, what was the entire purpose of this reform exercise? Was there a need for reform in the criminal laws? Now, the Law Commission of India, I think, had received 20 or 30 references for the last 40 odd years about reforms to criminal laws, and various law commissions have brought out reports on particular parts which they felt there was a need to amend, and so all of those reports are gathering dust, and no government did anything of that, and we got a completely new exercise which I think did not even look at what the Law Commission had done in the past. So was there a need for reform? Yes, there was. There was a need for reform, definitely in particular places in the law, and I'll touch upon those as I go along. Now, the articulation that we heard offered, which is not there in the statement of objects and reasons, but was discussed extensively in Parliament and also in press reports that the government put out, was, like Preetham mentioned, that this is decolonizing the laws is the main purpose. Like I said, it's not there in the statement of objects and reasons. But the statement of objects and reasons identifies, I've listed around 12, if you look at the statement of objects and reasons. They say this is a statement of objects and reasons to the Bharatiya Nyaya Sanhita. It says to strengthen law and order, focus on simplifying legal procedure so that ease of living is ensured to the common man being their words, not mine, making laws relevant to contemporary situation, providing speedy justice to the common man, creating a citizen-centric legal structure. All of this, till this point, to me, sound like criminal procedure. It's not substantive law, except maybe making laws relevant to the contemporary situation. Securing life and liberty of citizens. Streamlining provisions relating to offenses and penalties. Yeah, that's substantive law. Offenses against women and children, murder, and offenses against the state being given precedence by moving them forward in terms of where they are in terms of section numbers. Some offenses made gender neutral. We'll examine which ones were made gender neutral. Introduction of offenses punishing organized crime and terror activities, bringing them from special law into general law, along with deterrent punishment. New offenses relating to armed rebellion, subversive activities, etc. And fines and punishment being suitably enhanced. Now, twice they're talking about deterrent punishment and about enhancement of punishments. But we are told that this is not about dand, but it's about nyay. To me, it looks like it's more dand than nyay. It's about actually punishments being increased. Again, if you, what you mean by nyay and justice, it could, increasing of punishments could also be justice, but that's not how it's actually been defined. So I'll try and quickly go through 7 or 8 points on different aspects of the law. Like Shraddha said, looking at opportunities lost, things that require change, and things that, in my opinion, are confusing and don't make sense. First is in the context of defenses in the BNS. Again, brought forward from sections 76 down to somewhere in the teens now. The one defense I want to focus on is that of mental disorders, what used to be section 84 of the Indian Penal Code. Now, there were multiple calls for reform of section 84 of the Indian Penal Code because there was an understanding that it was based on the Macnaghten test, which came in the UK in the 19th century. It in fact wasn't, because the wording of section 84 was different from what the Macnaghten test was. And there's been a lot of movement in England from Macnaghten to where they are at this point of time. What we saw in the bill, which was incidentally, I think, tabled in Parliament exactly around a year back, was that the term unsoundness of mind was substituted all over the code with the term mental illness. And it said mental illness is as defined in the Mental Healthcare Act, which of course the Parliamentary Standing Committee came back and said, "This, do you really intend to broaden this as much as you seem to want to?" So therefore, status quo was kept. So it came back to unsoundness of mind, no reform to a section which required reform. We have various stereotypical understanding of what mental illness looks like, and that informs adjudication of cases under this section, which even the Supreme Court has recognized, saying that we need to get away from these stereotypical assumptions of what a person with mental illness will do or looks like when they're committing a crime. So a lot of my work is on sexual offenses, and like Shraddha mentioned, I had an opportunity of working with the Justice Verma committee, so I'm going to focus on some issues with respect to sexual offenses. We have a new section 69 of the Bharatiya Nyaya Sanhita, which, let me read, because I think without reading the section we won't get exactly what it's trying to do. So 69 reads, "Whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same has sexual intercourse with her, such sexual intercourse not amounting to the offense of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine." So here you see two parts. One part of the section talking about deceitful means, and the other talking about breach of promise to marry. Deceitful means has been defined to include false promise for employment, marrying by suppressing identity, etc. So it's not an exhaustive definition, so other things might also come in within that. Okay, so one is the term that is used there is sexual intercourse. Now, sexual intercourse, as interpreted by courts earlier, meant penile vaginal penetration. If you look at the IPC, or if you look at even the BNS, sexual intercourse in other parts of the code are defined as things that fall within what is now section 63, which was section 375 of the IPC, to include a range of penetrative acts. So is the intention to keep this only to penile vaginal penetration? We don't know, because that's not clear. Then what do you mean by not amounting to rape? Right, so this is an offense of sexual intercourse not amounting to rape. Now we see this language right in the previous section, section 68, which used to be section 376 capital C of the IPC, where you were talking about relationships of a certain nature, where you said this were consensual sexual acts, which is why they didn't amount to rape, but it was still punishable because of the fact that normatively you didn't want people in those relationships to engage even in consensual sexual acts. Now, if you're talking of sex by deception, why should it not amount to rape? Because sex by deception essentially conceptually means that it's rape. So are you creating a separate category where you're saying because of the fact that, yes, there was consent, even if the consent was vitiated by deception, we are going to consider it not rape? And not that I'm a fan of high punishments, but here is one where the punishment is lesser. There's no mandatory minimum which is there across this chapter, and so you are essentially saying that there's something lesser in this, which means the priority is not on sexual autonomy, right? It's something else which the section doesn't tell us what it is. Also, you see in the UK and the US, there's been a problematic jurisprudence on sex by deception and questions of conditional consent, and whether, because of this, the way this section is worded, courts will bring in that jurisprudence, which basically essentially says that if you consented to a penetrative act, then that's consent, right? So why should we even consider this as the offense of rape? So that sort of interpretation could come into the Indian context. Now, if we're talking about sexual autonomy, then the marital rape exception is retained, no change to that. And the question of gender neutrality, when you say gender neutrality is introduced in various sections, the Verma Committee, as you may remember, had suggested gender neutral victim, which didn't happen in 2013, doesn't happen here. But of course, we go to the extent now of removing section 377 and saying any non-consensual sexual acts by a man on another man or a trans person no longer remains an offense. So you create a void saying Navtej Singh Johar said this, when Navtej Singh Johar said consensual act, not about non-consensual acts. So you create a complete void. So in a few other provisions here was section 66 of the BNS, which deals with what used to be section 376 capital A of the IPC, which dealt with causing death while committing the offense of rape. Now that, even in 2013, excluded gang rape. And I think that was a clerical error, a drafting error at that point of time. This continues to exclude still, which means either there's no application of mind or it's intentional. Similarly, the definition of gang rape, again, in 2013, had said where a woman is raped by one or more persons constituting a group or acting in furtherance of their common intention. The earlier definition was and had become or. Again, I don't know whether that was intentional, because that was not the Verma Committee framing of it. Court have ignored the or and continue to interpret as it was earlier, but here was an opportunity to correct it. Again, that's not happened. The gender neutrality brought in the offense under section 76 of the BNS, which is assaulting or using criminal force to a woman with intent to disrobe. Right, that's been made gender neutral. That used to be gender specific earlier. Again, that, as per the Verma Committee recommendation, was supposed to be in public to deal with questions of caste-based violence. The public was dropped in 2013. And if you look at case law around it, there's an entire bit confusion of what is so-called outraging modesty, what is attempt to rape, and what is this section, right? So it then gives absolute discretion to the police to decide which section they will use depending on the punishment. Then voyeurism, section 77, He's also made gender neutral. Now I go back to what the statement of object and reason says, that is making laws relevant to contemporary situation. Now, this section, which used to be 354 capital C of the IPC, was based on the UK law in 2013, broadly based on the UK law in 2013. So it has a definition which focuses on expectation of privacy. And in the UK, the entire question was, is that expectation of privacy in a public place or not? So situations of upskirting, especially, or on an escalator or in a public place, the UK law was not bringing that in. I don't know whether we've had cases in court on this issue, maybe not. But so UK amends it in 2018 because of a movement which says, look, there's a void in this. So if you are making it in tune with contemporary changes, that should have been done, which has not been. Quickly to go to a couple of other things. One is offences against children. Section 95 of the BNS, it talks about hiring children to commit offences. Now, I know, again, maybe when we used to have discussions here in Delhi earlier, there was an entire obsession that people are hiring children to commit offences. And that now finds place here of there's this entire thing happening in the country where people are hiring children to commit offences. I don't know how true that is, whether any empirical data backs that sort of understanding. And if you go back to question of colonialism, we find the usage of the word seduction in various places in the code, including here, about seducing a child. Right. So what does seduction mean? Again, this sounds like Shakespearean romanticism. Courts have also interpreted it in some in that way. So again, that use of the word seduction is also continues, and that's not decolonization in my opinion. Okay. And in terms of homicide, we have section 106, which has been in the news because truckers objected to it, and 106.2 has not been notified. So in 106, again, the IMA has come back objecting to that section because it makes a exception for doctors, saying if death is caused by negligence by a registered medical practitioner while performing a medical procedure, punishment is less. Now, if you actually look at the jurisprudence of the Supreme Court, it actually had virtually excluded doctors from what used to be section 304A, but by the way they interpreted it, unwittingly or unintentionally, seems to be brought back, because now you've brought it back and just reduced the punishment. And for the definition of grievous hurt, earlier it said that if a person was unable to carry on the regular activities for 21 days, that would be grievous hurt. Now it's paid 15 days. That why the change from 21 to 15 is not particularly clear. How much time do I have?
Minute.
Okay. Right. Quickly on offences against property, section 221, which defines property, removes the word corporeal. So under the IPC, movable property said it is corporeal property. Now the word corporeal is out. So does it mean incorporeal property is included within offences against property is one question. Then we have offence of snatching, which was an offence by state amendment in Punjab and in Haryana. Was there a need to bring it across the country? I don't know whether there were that many cases of this way snatching was defined. A positive thing is removal of the offence of being a thug, etc., which were, that is decolonization, where you're getting things which criminalize people based on their identity. So quickly to look at offence against state and public order, organized crime, defined in section 111, you have two or three things there. Of course, this is Makoka and other legislations being brought into the penal law. So you have preparatory acts being criminalized, which under the IPC were just one or two. Now we have this entire set of preparatory acts. Membership of a crime syndicate is criminalized. Possession of property being derived from commission of organized crime is punished. There's no mens rea requirement. So if I'm in possession of property from commission of organized crime, that's an offense. In terrorism, there's a mens rea requirement saying knowingly in possession, but for organized crime, that mens rea requirement is not there. Then there's also an offense of not being able to account for property which is made in the context of organized crime. And more problematically, you have this crime of petty organized crime, which has this range of things included: thefts in the car, skimming of credit cards, etc. Which, who are you targeting in this sort of offenses? And of course, our movement from Deshdroh, not Rajdroh, section 124A to section 152, uses the word purposely as a mens rea standard. Right? I've not come across purposely in any sort of criminal theory of what purposely actually means. And of course, everybody's been talking about encouraging feeling of subversive activity. All of us might be encouraging such feelings by talking here, which is an offense under section 152 of the BNS. And 107 of the BNSS, which talks about, we take the entire BNS and say the police officer or the court has now the power to attach and liquidate property if they think you have some proceeds of crime from committing any offense under this legislation. So I think read completely together, we get a situation where, I'm accused of something, my property is liquidated, distributed to people who are affected by the crime, rest to the government. And then if I'm acquitted, I don't know whether the property comes back to me at a later point of time. Yeah, so I'll stop here and maybe we can continue. Thank you.
Thank you. Thank you, Mrinal. That was really incisive. And I'm sure it'll be a jumping off point for a lot of questions when we go into the question answer session. Right. So now for our second panel, to throw light on modifications to the punishment regime, we are privileged to have Dr. Anup Surendranath. Dr. Surendranath is a professor at National Law University, Delhi, where he teaches criminal law, constitutional law, among other subjects. He holds the position of Executive Director at Project 39A, a criminal justice research and advocacy program that provides pro bono legal aid to undertrials in Delhi, Nagpur, and Pune, and generates cutting-edge research on multiple aspects of criminal law and practice, ranging from issues of penal theory and practice to forensics and mental health. His own extensive publications provide rich theoretical and empirical insight into capital punishment in India. And I am certain that your experience and expertise in the area will enrich our discussion on this topic today. Over to you, Anup, 15 minutes. Thank you.
Good afternoon, everyone. Thank you, Preetham and Shraddha, for putting this together and making me a part of this. In my 15 minutes, just want to start with a couple of broad observations overall on what is being attempted here and spend most of my 15 minutes on specifics on punishments, which is what I've been asked to speak on. More broadly, I would like to say that I think there's a need to question the concept of reform, right? And then I think it's a word that has been bandied about in the context of these laws, that this amounts to reforms in criminal law. And I think the fundamental question we need to ask is when does change amount to reform, right? And are all changes reform? And in that context, I would like to present the provocation that reform necessarily is an empty idea, because in terms of substantively it means nothing, right? And to apply that idea of when would you say that in the criminal justice context that certain things amount to reform? Is higher punishments reform? When in terms of procedure, when would you say that something is a reform, right? So it is necessary. The point I'm trying to make is that reform generally in the context of law is a contested concept, right? More so in criminal justice. We are not really sure which directions of change, be it on substantive offenses, procedure, or evidence, can be characterized as reform and what is just mere change. And I sort of invite all of you to think that not all change is reform, right? So then moving on, I just want to present three broad issues or frameworks of the intersection between constitutional law and criminal law within which to look at these changes, and would like to particularly invite us to reflect on the fact that this intersection is a rather weak one in the Supreme Court's jurisprudence, right? And particularly along three parameters of criminalization, of vagueness, and one of proportionality of punishment. All three questions very integral to the idea of criminal law and what is provided in criminal law. And in all of these areas, be it what is it that the state can criminalize, should that be a question for constitutional law? Should that be a question for judicial review at all? Or is it a sphere of criminal law making that the courts should necessarily stay out of in terms of what we should criminalize, or how should we think in terms of constitutional law of what can be criminalized and what should not be criminalized? And of course, there's then the attendant question of we can think about what should be criminalized. There is also the attendant question of how to criminalize it, right? And how much to criminalize it, which is then the question of proportionality, right? Of punishment. I'm not talking of it in terms of Article 21 proportionality, but in terms of proportionality of punishment, right? The idea that if you can't have death penalty for theft, well, maybe you can, but I don't know, right? You can't. The idea that when will you say that punishment is disproportionate, right? Would you say the fact that if you cause death by rash and negligent driving and you don't report that, 10 years is disproportionate? How do you, in a constitutional law framework, start to think about this connection between what you're criminalizing and how much of punishment are you ascribing to it, right? And that's, again, as I said, a weak area for the court's constitutional jurisprudence, this intersection. Third, and I think of great contemporary significance, is vagueness as a constitutional problem in criminal law, right? Vague provisions. And I just want, of course, we have seen that in Shreya Singhal in the context of 66A, but I submit that that's still not giving any meaningful direction on when will you say that a criminal law provision is vague, and therefore the vagueness amounts. Of course, we can argue that all language is vague and therefore all law is vague to some extent, and we can get into that deeply philosophical question, but that's not, when does vagueness amount to unconstitutionality, right? And I think we need to desperately answer that question, and as Mrinal also spoke, some of these provisions are so vaguely worded, it is almost difficult to imagine what exactly is being criminalized. Right? Even, one of the principles that Macaulay was guided by when he was drafting this is that wanted to give clarity on what action is being criminalized. So even in 152 or in the provision on false and misleading information, you have no idea as to what activity exactly will end up being punished or criminalized. So I would submit that these three frameworks of looking at the intersection of constitutional law and criminal law is A, underdeveloped, and B, there are very serious consequences of that underdevelopment of constitutional jurisprudence as far as these three laws are concerned. And I guess we are seeing that playing out, and when some of these constitutional challenges will come, we will see that, right? I just want to take off on one of these points on proportionality of punishment, and in the context of death by negligence, right? How should we think about the three categories of punishment in 106 BNS? That there are three categories of death by negligence. One is your vanilla death by negligence, which gets you 5 years, right? Then there is the easygoing provision that if you're a medical practitioner who causes it during the course of doing this medical procedures, you get 2 years. And then, of course, if you cause death while you're driving a vehicle and you don't report it, you get 10 years, right? Is this a question for complete legislative deference in that sense? Should we leave it to say that, yeah, really, there's no point for a court to get into this business of saying that it can categorize death by negligence into these three categories, and that it can prescribe whatever punishment it wants to each of these categories. I'll leave you with that. Also taking on the point on Mrinal made that this is nyay, not dand, empirically just does not play out in terms of these laws. There are over 30 provisions in the BNS where there is enhancement of punishment, right? As compared to the IPC. And I couldn't find where there is reduction of punishment. I couldn't find any provision where there's reduction. There are over 30 instances of enhancement of punishment, either in terms of the duration or the nature of the punishment itself. Mandatory minimums making a very, very strong presence felt across various provisions that mandatory minimums have to be done. And we've seen what mandatory minimums do in the context of, and Mrinal's own work speaks to that in terms of what mandatory minimum does, at least in the context of sexual violence. And then therefore you see, again, I go back to the point that I make about reform. Is this reform? Is the approach of the state that punishments need to be enhanced, and there is a general enhancement of punishment across the BNS, is that to be viewed as reform, right? And in what conception of criminal law, and there might be competing conceptions of criminal law here, that is this, and what values must inform us as labeling something as reform or not, and I think there's a general trend towards increased punishment, and I would submit that that is regressive approach to criminal law rather than any sort of progressive approach to criminal law. It is a regressive approach, the enhancement of punishments. Next, in the staying with the spirit of enhancements, the confusion as far as life imprisonment on the one hand and life imprisonment for the remainder of natural life, that confusion persists. It was a confusion that was introduced in the context of sexual violence laws, and of, do they mean the same thing, right? In some provisions, the IPC says only life imprisonment. Now it's, and even before some of the amendments after 2013, 2018 said life imprisonment to the remainder of natural life. The question really was, are state governments' remission powers as a result of this excluded, right? We don't have clarity from the Supreme Court on that, right? In Shatrughan Bhaban Meshram, the Justice Lalit indicates that these two have to mean different things, and perhaps that when the case is right, that the direction in which to go is that if the punishment is life imprisonment for the remainder of natural life, as in legislative language, that means that the state government's remission powers under the then CRPC and now the BNSS stand excluded, that the state government cannot exercise these remission powers. But I assume this is a question that will come to the courts sooner than later. Of course, the on remission powers itself under what is the 435 CRPC and now 477 BNSS, where offences are linked to the central government. The law already was, through judicially developed law, that where the offences are linked to the central government, even though the words in the CRPC said in consultation with, for remission, the state government would have to consult the central government, and it had been read as concurrence. That has now been legislatively acknowledged and provided for, that whether offences linked to the central government, the state government needs the concurrence of the central government to remit the sentences, right? So that's community service, good move, one would say, but as with most of these good moves in these bills, you're hesitant to call it good because immediately you want to qualify it with a but, right? As with anything, any example that you give, right? And I'll get to some of those, one of those better examples. But with community service, there are about 6 offences, if I'm not wrong, that have identified community service. Again, no basis on which why those 6 are. I invite all of you here to go through those 6 offences and tell me why, what connects those 6 offences as to why only those are provided with community service and not the others. Also, what is the definition of community service in section 23 of the BNSS provision? I think we should watch this very closely as to how this evolves. What do they mean by community service? Judges can sort of assign work which the court may order any work, ask a convict to do any work to perform as a form of punishment that benefits the community Any work that benefits the community, a court can order. Now, we can only imagine the many creative avenues that are opened up into what will amount to benefit of the community, right? And again, no legislative guidance on what is to be done. Again, curious use of community service. Again, as I said, going back to my point, I don't really know where it is used and why it is used there and not in other places. In theft, in 3032 of the BNS, the proviso to section 3032, if you are a first-time offender on theft, and if you return the goods you've stolen or you make good the value of the stolen good, you shall necessarily be only sentenced to community service. Okay, fair enough, good enough. I'll come back to the problem with that. It essentially is forcing you to plead guilty, but anyway, I'll come back to that. But you go to the next section, which is 304 for snatching. Great example for a class in interpretation of statutes. Okay, I just for the fun of it, I just want to read snatching ka definition, right? Theft is snatching if, in order to commit the theft, the offender suddenly or quickly or forcibly seizes or secures or grabs or takes away from any person or from his possession any movable property. So, I don't know what the meaning of the words like suddenly, quickly, forcibly, grabs, takes away. Because obviously the legislature cannot say this is for chain snatching. It wants to say that, it cannot say that, right? And therefore it ends up saying this, right? Now, anyway, that aside, if you look at the punishment for first-time snatchers, unlike first-time theft people, there is no community service. Yeah. I didn't want to. Persons convicted of theft, right? This kind of unprincipled lawmaking must worry us, right? That there's no attention to detail. The most charitable case to make is that there's no attention to detail to achieve consistency, right? And there is no reason to say why first-time person convicted of theft can should get only community service, but that option is not even available if you snatch something, snatch any movable property, right? The proviso is particularly problematic on theft, which allows for community service, says that provided that in cases of theft where the value of the stolen property is less than 5,000 rupees and a person is convicted for the first time, shall, upon return of the value of the property or restoration of the stolen property, shall be punished with community service, right? This is a dangerous provision as far as pleading guilty is concerned, right? If you look under trial statistics across the country, theft is a major component of under trial populations, right? That people accused and arrested and put in prison, theft is a major category. Yeah, 1 minute, great, all right? So that is something that we'll have to worry about. Just very quickly on 436A, one of the good things about this is that the 436A provision which said that if your trial has not been completed, if you have not, by the time you've completed half of your maximum possible sentence, you are to be released on bail. That is the provision of 436A. The good part of these changes is that now it says not half, as soon as you complete 1/3, you are eligible for release. But, right? Two buts there. There is an expansion of the disqualification for this. In 436A, you were disqualified from getting the benefit of this if you were being arrested for and imprisoned for death sentence offenses. Now, life, if you are in for a life imprisonment offense also, you are disqualified from the benefit of this provision. Second, right? Again, if there are any, under 479(2), any investigation, inquiry or trial in more than one offense or in multiple cases, if anything is pending against you, irrespective of what your offense is, you are not eligible to the benefit of this 1/3 maximum. If you've already undergone 1/3 of the maximum sentence, that you are not eligible for that.
More than one offense.
More than one offense or cases.
120B
Correct.
added.
Correct. Exactly. What does that mean? What is the meaning of offense under this, right? And it does a good thing of saying, look, why is 436A not led to reduction in under trial populations in our country? Because it places the burden on the accused persons to bring it to the attention of the court that they have completed half their sentence, right? And they themselves don't know when they have run out of half their sentence. Good change in the sense that now it makes this the problem of the prison superintendent, right? And therefore the prison superintendent has to flag that this person has finished 1/3 of their sentence. But no prison has the capacity to do this, right? They themselves don't maintain that information. Given the sheer number on under trials we're talking about, prison superintendents don't have the ability, and even the under trial review committees that the court has set up are just a complete failure. I have left out on because of time the pet issue of the death penalty and mercy petitions. Shocking set of amendments, really, and an attempt to curb constitutional powers of both the court and the president and the governor by saying that no appeal against the decision of the governor or the president is allowed. Thankfully, that is the inaccurate language used, because nobody is appealing the decision of the president or the governor. I'm glad whoever drafted it that way, because you're filing a writ petition. You're not appealing the decision. You're filing a writ petition challenging the judicial review. I mean, that is a different thing of what happens to those judicial review petitions. But thankfully, it is worded in a manner that makes no sense, right? Thank you so much, and I'm sorry for overstepping my time.
Thank you, Anup. That was really informative. And I hope that we can get into some of these questions that were missed out on death penalty and so on in the question answer session. And so hopefully the time limit won't have curbed you too much. Now, we are honored to have Ms. Rebecca John to share her views on amendments to criminal procedure today. Ms. Rebecca John is a senior advocate practicing in the High Court of Delhi, the Supreme Court of India, as well as in trial courts. Her eminence as a criminal defense lawyer needs no introduction. She has argued a number of high-profile cases and is experienced in arguing both white-collar and blue-collar offenses. So we are really lucky to have you here, ma'am. I personally remember having attended a criminal procedure class that she taught at NLSIU back in 2014. And I can tell you that the clarity of the trial process in my head since then has been crystal clear. So thanks for that. And hopefully we all can have the benefit of that again today. So over to you, ma'am, for 15 minutes.
Thank you, Shraddha. So what Anup said about lack of attention to detail is littered in the new BNSS, which took over from the CRPC. Because the time is short, I plan to concentrate on some areas. One is the remand provisions. I think it's very important that we talk about them. The introduction of a preliminary inquiry prior to the registration of FIR, the provision of a zero FIR, ex parte trials as far as proclaimed offenders are concerned, the procedure in complaint cases, trial through electronic means. Everybody seems to be fascinated by this. It's the worst thing that could happen to us. Summary trials and the lack of appeal, discharge in summons cases, which is probably the only good thing I can find in this, and the expansion of the earlier provisions of 311A, where a magistrate could take your handwriting. Now he can take a series of things like voice samples, etc., and the introduction of certain new documents within the definition of documents in section 94 of the BNSS, which was earlier 91 of the CRPC. I'll also briefly touch about the lack of safeguards while we talk of the introduction of provisions of UAPA and MACOCA in the penal code. Some of the safeguards given in the special statutes are missing, particularly in relation to the sanction provisions. So let's just look at remand first, 187 of the BNSS. I'll take the next lifetime learning these provisions, but never mind. Now, it used to be 167 of the CRPC. There is a change in subsection 2, and let's just examine that. Subsection 2 talks of an extended period. So the 15-day period remains. Nobody is contesting that. But police custody remand under the older law was the first 15 days. Now it has. It can take place anytime between the first day and the 40th day, anytime between the first day and the 60th day, depending upon the gravity of the offense. That is bad enough. But what is worse is the ambiguity and the deletion of 3 critical words in subsection 3. Subsection 3 says that the magistrate may authorize the detention of the accused person beyond the period of 15 days if he satisfies that adequate grounds exist for doing so, but no magistrate shall authorize the detention of the accused person in custody beyond 60 or 90 days. Now, what has been deleted are the words otherwise than in police custody. I would still argue that subsection 2 allows you to have a truncated police custody remand period up to 40 or up to 60 days. But the deletion of the word otherwise than in police custody has led some of us to feel very anxious about this provision, because does it mean that in a given circumstance, the magistrate can allow police custody up to 90 days, or can it allow police custody up to 60 days? It needs to be clarified through a decision of the court. Now, notwithstanding that, forget 3 for the time being. If you only look at 2, the fact that the legislature thought it fit to expand the period of police custody from 1st to 40 days or 1st to 60 days, albeit for a total of 15 days, and allow the police to keep coming back in tranches for 2 days police custody remand, 3 days police custody. How does it affect the rights of a citizen? Now, police custody remand is bad enough. I don't think many civilized countries have this concept. But beyond 15 days, once you're sent to judicial custody, as practitioners, we tell our clients, move for bail now. You're kept on the edge, because up to 40 or up to 60 days, they'll say, no, we haven't finished. We can still come back. Investigation is at its nascent stage. So you are effectively denying bail to an accused person for a minimum of 40 or 60 days, as the case may be, because the police can ask that our period, our total 15-day period, is not yet over, which was otherwise over in the first 15 days. A very, very regressive section, if I may say so, notwithstanding the complications that subsection 3 has introduced. Now, other than that, moving from here, the other provision, which I find quite amazing, is section 173. Now, if you were to look at section 173, which introduces the concept of zero FIR, it's actually not as simple as it appears to be. It says that every information relating to the commission of a cognizable offense, irrespective of the area where the offense is committed, may be given orally or by electronic means to an officer in charge of the police station, if given reduced in writing. Now, this concept of zero FIR has been judicially recognized. I don't know why it was introduced in this form. But what is problematic is, so suppose the offense is committed in Delhi and the complainant is in Guwahati. The police station at Guwahati can register the zero FIR because she's made the complaint there. At what point does he return it to the police station of jurisdiction? There is no clarity on that. And if you were to read 173 in letter and spirit, then because so much of it has been amalgamated in this section, that's a problem with these 3 acts, this wholesale amalgamation within sections of unrelated events and unrelated things. But if you were to read 173, I could argue that the police officer at Guwahati has the power to conduct a preliminary inquiry. He has the power to arrest. He has the power to investigate. He has the power to attach properties, which attachment is outside the PMLA regime under section 115 and 117 of the BNSS. So this is there's no clarity when he returns it to the police station of jurisdiction. Absolutely no clarity. Now, in such a situation, a rape case of the dentist, where her parents went from police station to police station trying to register an FIR, and everybody shooed them away saying, it never happened here. So I can still accept the fact that you introduced the concept of a zero FIR. But you must then say at what point that police officer's powers end, and at what point he must transfer the case to a police station of jurisdiction. That is completely absent, at least to my reading. Now, if that is so, the potential for misuse is enormous, because you can sit happily in your house in Delhi, and somebody has registered a case against you in a jurisdiction far away, and that police officer is continuing investigation against you, and you don't even know about it. So all of this can lead to a crazy criminal justice regime. Now, within that 173 itself, there is 173.3. As I said, the amalgamation is so brainless. If you see 173.3, it says that without prejudice to the provisions contained in 175, which relates to investigation of cognizable offences, on receipt of information relating to the commission of any cognizable offence which is made punishable for 3 years or more, but less than 7 years, the officer in charge of the police station may, with the permission from an officer not below the rank of the deputy superintendent of police, considering the nature and gravity of the offence, proceed to conduct a preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in a matter within a period of 14 days, and proceed with the investigation where there exists a prima facie case. Lalita Kumari, to my understanding, said that if a cognizable offence is made out, you have to register an FIR. Now, why have you introduced the concept of a preliminary inquiry? Is it logical? Even in your introduction, it says if it's less than 3 years, no preliminary inquiry. If it's between 3 and 7 years, preliminary inquiry. I would think if it's less than 3 years, hold a preliminary inquiry, because there's every chance of a false implication. If it's 3 to 7, it's a graver offense. And if the offense is made out, why should you have a preliminary inquiry? So they've inserted preliminary inquiry for a graver offense, and they've let out, and they said a less serious offense, there is no need for a preliminary inquiry. This, remember, comes within the chapter, within the provision of the zero FIR. So all of this, the zero FIR man sitting in Guwahati can do. So this again is a extremely problematic provision. Now, moving on. There is this concept of ex parte trials for proclaimed offenders. If you could come to 356 of the BNSS, it talks of ex parte trials. I think I'll pull this out. What it basically says is that notwithstanding anything contained or any other law, whether or not, if a person is absconded to evade trial and there's no immediate prospect of arresting him, it shall be deemed to operate as a waiver of the right of such person to be present and tried in person, and the court shall, after recording reasons in writing, in the interest of justice, proceed with the trial in the like manner and with the like effect as if he was present. Now, there is of course the concept of people who are declared proclaimed offenders, and their trial is separated from the rest of the pack. But I have never seen words like this, that it will be deemed to operate as a waiver of the right of such person. This can also lead to tremendous misuse, because there is every possibility in today's India that some random case is registered in some corner of the country. I don't know about it. My right to contest that case goes. Evidence is recorded in my absence, and it will operate as a waiver. I can't come back and say. It, of course, has an interesting provision, which again is a little illogical, in subsection 2.3, which says that there is a provision which says that where subsection 3, where the proclaimed offender is not represented by any advocate, he shall be provided with. The proclaimed offender is not there. What do you mean if the proclaimed offender is not represented by an advocate? So it's all done in a way which lacks clarity, which lacks intelligent, examination of how these things happen. Now, the concept of proclaimed offender, it has worked. People who don't participate, who evade arrest, who don't respond to summons, against whom warrants are issued, attachment proclamation is issued, etc., their trials are separated. But thus far, they have come back if they are rearrested, and they have pretty much received the same rights that a person who was there in the first instance received. By saying you waive off that right, you don't take into account those cases where there is genuine false implication, where the person doesn't know that a case against him exists in some corner of the globe. Then another very, very fancy provision is Section 223. It introduces something which is unknown to criminal jurisprudence. So as you are all aware, there is a state case procedure and there is a complaint case procedure. In the complaint case procedure, normally a complaint is filed before a magistrate. The magistrate proceeds to examine takes cognizance, proceeds to examine the complaint under his and her witnesses, then decides whether it's a good enough case to summon or to dismiss the complaint. Now, under Section 223, we have the introduction of a magical provision. It says a magistrate having jurisdiction while taking cognizance of a complaint shall examine so and so, provided that no cognizance of an offence shall be taken by the magistrate without giving an accused the opportunity of being heard. Where does the accused come at this stage? And if he comes at this stage, you're going to hear the accused prior to taking cognizance. At what point are you going to shoo him away from your court? At what point will the complaint case procedure take off? What is the reason that you've given him or her the opportunity to be heard at this stage? It completely defeats the right of a complainant to set up a case. There are enough checks and balances between the time cognizance is taken and summons are issued in the form of what used to be 202 and whatever is the parallel provision now to have an inquiry. Now, by giving the accused an opportunity at the initial stage to be heard, much like the preliminary inquiry, you have made this an impossible provision to take forward.
It's a mini trial.
It's a mini trial. And if you are a public servant, you must be respected even more, because it says that every public servant who is against whom a complaint is made is given an opportunity to make assertions as to the situation that led to the incident so alleged, report containing facts and circumstances of the incident from the officer superior to such public servant is received. The servant against whom you make a complaint additionally gets a right to assert why he did what he did. His superior officer's report will be called, which will be considered before a magistrate takes cognizance. Look at the shift and look at the manner in which the Nyaya Sanhita and these laws, which are anti-colonial, have worked to the benefit of people who are in power and in authority. So this is as far as complaint case procedures is concerned. If you look at Section 530, trial through electronic means. Now, I actually never understood the fascination with video conferencing beyond a point. Trials, examination of witnesses, cross-examination, confrontation. These are all supremely physical acts, and you cannot do them through video conferencing unless there is absolutely no choice in the matter. As a rule, this should be an exception, never the rule. Now, what has 530 done? 530 says everything can be done through video conferencing, from issuance, service, execution of summons, warrants. How do you do that through video conferencing? Executing a warrant, I don't know. Examination of complainant and witnesses, recording of evidence in inquiries and trials, all appellate proceedings. While it's possible to have long arguments on video conferencing, we've all done it. But I believe examination of witnesses, it should not become the norm. And there is already in places like Delhi a tendency, in all cases, it started with 138 cases, to say, do it through video conferencing. So complainant sitting in Dubai, accused is coming on every date of hearing because he doesn't get an exemption, and some random procedure is being adopted. This again is dangerous. It will do violence to the letter and spirit of criminal law. Then, have I done with my time? Minute and a half. Okay. Summary trial. Sections 283. Now, this provision existed even in the earlier code, but with one remarkable exception, and the exception is that if the summary trial procedure is followed, the proviso to subsection 2 says no appeal shall lie against the decision of a magistrate to try a case in a summary way. So, and when so there are a whole lot of offenses mentioned there. They are in the nature of not very serious offenses, but a summary trial procedure eats into the rights of an accused person, and by not allowing an accused person to contest that procedure, you're again taking away an important right. The one provision I actually like is section 274, which is a summons case procedure. Earlier, if you'll recall, there has been quite a bit of judicial back and forth where initially there was a judgment called K.K. Matthew versus State, where the Supreme Court said that the magistrate has the power to review his own order of summoning in summons case procedures, because otherwise in summons case procedure there's no provision for discharge. For the first time, that has been clarified, and there's been a proviso which has been introduced which says that if a magistrate considers the acquisition as groundless, he shall, after recording reasons in writing, release the accused, and and such release shall have the effect of a discharge. So this is in keeping with the warrant case procedure, and summons case procedure is in keeping with warrant case procedure. An opportunity has been given for discharge, which I think is a good thing. Other than that, the one thing that, if you were to look at section 349 of the code, which is an expanded power given to a magistrate who used to earlier only take specimen signatures and handwriting of people for purposes of comparison in aid of investigation. Now the magistrate has the right to take not just specimen signatures, but also finger impressions as well as voice samples. This is, of course, in line with the judgment of the Supreme Court in Ritesh Sinha. So, voice samples can also be to be given to the magistrate, which can act in aid of investigation. 91, what used to be 91, a very, very important section of the code, is now 94, and there are certain interesting insertions in 94 as well, including, if you will see, earlier it was only the power of the magistrate or an officer in charge of a police station to summon a document or a thing. Now that has extended to all forms of electronic communications. Guard your mobile phones and your laptops. All forms of electronic communications, including communication devices, which are likely to contain digital evidence. All of this can be summoned by the use of section 94. Of course, mercifully, the test of desirability and necessity, which is the paramount test before you decide to summon a document, continues to remain in 94. There's mandatory collection of forensic evidence. He's the best guy to tell you about that, where they say you must videograph scenes of crimes and you must follow protocols which are necessary for investigation, as though none of this happened before, but this is all put there in section 176. You've talked of community service, so I won't talk about that. There are some absurd timelines which will only be followed in breach, which will never be fulfilled. And lastly, I'll end by saying that while you've included large chunks of UAPA and MACOCA within the penal code and given the right to decide which of the two, whether it is UAPA or the penal law, to a superintendent of police. So your fate is in the hands of a superintendent of police who will decide which of the two acts will apply, either UAPA or the penal code. But what is worrying is that some of the safeguards in whatever form that exists in UAPA, for example, 45.2 with respect to the multi-layered sanction provisions, are completely absent here. what is good is that if these provisions apply, then unlike 43D5, there are no twin conditions for grant of bail. I shouldn't say that very loudly. They may be introduced very soon. This largely is some of the topics that I wanted to flag and highlight, and we can discuss them in detail later. Thanks.
Thank you so much, ma'am. I think we're all grateful to you for having highlighted some of these frankly shocking changes to criminal procedure, and hopefully we can get into them more in the question session. Our fourth panelist today is Mr. Sanjoy Ghose. Mr. Ghose is a senior advocate practicing in the High Court of Delhi, the Supreme Court of India, as well as in arbitral tribunals. He is also a published author, and his book, How Gaurango Lost His O, is a humorous narrative, which I would recommend anyone who hasn't read it yet. This panel is really heavy on criminal lawyers. And so I think Sanjay sir brings the much needed balance of the perspective of someone who also does a lot of civil work, labor and service matters. So, and perhaps because we study evidence law in conjunction with CRPC and substantive criminal law, we seem to think of it as criminal law. And that is, in fact, the rubric under which we're discussing it today as well. But it serves well to remember that it is, in fact, a neutral law that applies across the board. So where it is fitting that we have Sanjay sir here today to talk about the changes in the rules of evidence, begrudgingly initially at least, but hopefully now on board. So we're happy to have you here, sir. Over to you for 15 minutes.
Thank you, Preetham and Shraddha. To take on from where Shraddha ended, begrudgingly, we choose our own demons, right? Asuras. So I wanted Bhanasur, Bharatiya Nagrik Suraksha, Bhanasur. But I was told that Rebecca, my dear sister, has called the dibs. So I was stuck with evidence. Mercifully, the least impacted of all the three legislation. I was cribbing. I've given Shraddha earful, her lovely husband Sridhar also earful. But forced to go through this act, I found so many gems, some of which I'll share with you today. But before that, just a clarification. The irony of all this, I spent substantial part of my career as a labor lawyer where the evidence law doesn't apply. Now I do a lot of arbitration cases and this law says Evidence Act will not apply. So, but still we will speak about evidence. Now, the only commonality in this decolonization is that 12 odd people sat in the NLU office and made this new law. And 12 odd people on March 12th, 1872 sat in the, actually 13, I'm so sorry. 13 odd people on 12th March 1872 sat in Calcutta. It was called Calcutta then, at the Viceroy's Legal Council and drafted the Indian Evidence Act. And unfortunately, for this Bharatiya Shakshya Adhiniyam, there was no Sir James Fitzjames Stephen. And in 1872, after this whole day's debate happened, one of the members, John Scratchy, said that India owed to Stephen a great debt of gratitude and predicted a really great improvement in the administration of justice in India. But we still have to give that kind of accolades to the authors of this law, Bharatiya Shakshya Adhiniyam. As you know, that it has hit the roadblock from word go. A lot of South Indian states and lawyers practicing, our brothers and sisters from South India, I see sir over there, who have actually said that these names are too Sanskritized. So now, now we have this age where you have the Aircraft Act being replaced by the Bharatiya Vayu Vahan. Now, Adhiniyam. Now tell me how many people call the aircraft a Vayu Vahan? Shakshya in Bengali will become Shakko. And Preetham will tell you what will become in Assamese. So, Tamil, I don't know. So that is an issue. Now, by and large, as I said, that in this reassignment surgery, the least damage has been the Evidence Act. The Evidence Act has gone through a few changes. Sir James Stephen's classical work has gone through a few changes. As you know, we had, when you had Tukaram's case, and you had the dowry deaths, in 84, you had certain changes made to the Evidence Act at that time on rape, on dowry. Then you had the issue of technology coming. So you had in the 2000 and thereafter, you had the Information Technology Act, and there were a lot of changes on electronic evidence, etc., which happened at that time. So it is not that this law has remained pristine and untouched, but by and large, the amendments which have been made here are only incorporating, or rather fine streaming them. Like, for example, what is 65A has now got a substantial section. A, B, C have gone. Those amendments have been made into the normal section. Now, was there really a need for dealing with a new law? We could have simply amended and changed the name and said now Indian Evidence Act will be called Bharatiya Sakshi Adhiniyam, and spared us to relearn. Rebecca and I have to relearn section 32. We know it by heart, dying declaration or some other section. So let's deal with first the positives before we get into the bashing of this law. The positives are that, there have been certain kind of changes that they have made. Like, for example, the word ravished, the word bania, the word lunatic, all these words which were there in the law have now been changed to ravished has become rape, bania has become business person, lunatic has become unsound mind. Now, I intend to, okay, let's finish some few positive things before we go further. Then, of course, you had the whole load of class of legal practitioners, vakils, pleaders, attorneys, barristers, all of them have been made into advocates. Now, I'd like to be a little less serious, and let's deal with some fun, because Anup was talking about attention to detail. Let's see the attention to detail in this law. And I really had a great time going into the attention with details. Take this, for example, and before I get into the attention with detail, let me tell you the amazing fact that Sir James Fitzjames Steeple actually lived in India during that brief period, and he had the lived experience of India in the law. For example, in section 48 of the Evidence Act, one of the examples on right of custom, he says, the right of a villager of a particular village to use a particular well, kua, is a talao, is a general right within the meaning of this section. So this whole use of wells and all these disputes on well finds an illustration there. In 1872, our makers have continued with that. Of course, they did not make any change. Now, let us see in Amrit Kal what kind of changes they have made. This was a time to actually deal with the anachronism. Obviously, in 1872, Act will be dated, right? So there's certain anachronistic provisions or examples and illustrations which you could change. But unfortunately, the letters could not transition as tools of communication to emails. So all the illustrations still talk about letters. Clubs could not transition to weapons like, let's say, an automatic. It's still clubs, beating with a club. Shipwrecks, like you have in section 19 of the BSA, still remain. I mean, ships have gone. Now we are in age of aircrafts. Indigo, as you have in illustration to section 94 BSA, still remains. Now is the day of Indigo Airlines. You can give an example of Indigo Airlines ticket in the illustration of trade and not trade in indigo. But obviously, the makers were so mindless in their copy and paste. Forget indigo and Indigo Airlines. Look at the indexation. Now see the seriousness of this in illustration to section 34 of the Indian Evidence Act. If you have the act, see it. They're talking about a book of accounts having an entry of how much? Rupees 1,000. Rupees 1,000 in 1872 was shitloads of money. Now, the makers of this Bharatiya Sakshi Adhiniyam have not changed 1,000. It still remains 1,000 in 2024. Can you imagine anyone going to court in 2024 for 1,000 rupees? I can't. So, even in the cut and paste of the illustrations, because primarily this is an act where they've just rearranged sections. I will tell you where they have made a few changes, but primarily it's rearrangement of sections. Now, there have been certain, in the copy paste, certain kind of political correctness has come. Now, my city of birth, Calcutta, the second city of the empire, had an unfair large share in the illustrations. Calcutta has vanished, Varanasi has come in instead of Calcutta. Of course, Lahore, London have all gone. Karachi, all the illustrations, London, Lahore and Karachi have gone. Now, unfortunately, now look at this. In their change also, it's hilarious. Like, for example, in section 96 of the Indian Evidence Act, which is now cut and paste to section 99 of Bharatiya Sakshya, there are two illustrations. One is about when you have one city or confusing two names, how do you deal with it? So the original example, Sir James Fitzjames Stephen, I love saying Sir James Fitzjames Stephens, had given Hyderabad in Deccan and Hyderabad in Sindh. So now that they have changed. They made it Ramgarh in Rajasthan and Ramgarh in Uttarakhand. That they have done. But the first part says, my white horse. Now, my white horse is valued at 1,000 rupees. That my white horse still remains 1,000 rupees. Now, I will ask, I'm told one very established criminal lawyer has been a part of this thing. I would love to give that gentleman 1,000, not you. I would love to give that gentleman 1,000 rupees and give me a horse. Yeah? I don't mind white, blue, jo bhi hai, give me a horse for 1,000 rupees. So look at the illustrations that they've done. Now again, not all horses are treated equally. Let me tell you. In section 93 of the Indian Evidence Act, which deals with ambiguity, Sir James Fitzjames Stephens had said, if the horse is, I will sell you the horse for 1,000/1,500 rupees. This they have made 1 lakh, 1,50,000. But if you see the latest episode of Panchayat, you will know that they went and bought that horse for 4 lakhs. So even in 2023, you are indexing at least this horse. My white horse you did not index. This horse you have indexed, given the indexation, without knowing that this budget will take away the indexation benefit also. But there also you've gone 1,000. So, this is, but my favorite blooper, before I get serious, my favorite blooper, now Rebecca listen, my favorite blooper is section 94 of the Evidence Act, which has been made section 97 of the Sakshya Adhiniyam. Sir James Fitzjames Stephens had given 300 bighas as the illustration of a land in Rampur. So they said, Lahore to nahi use kiya, Rampur theek hai, that's kosher. But they forgot one small little fact. The UP Ceiling on Land Holdings Act 1960 has said more than 66 bighas no one can own. But illustration wohi hai, 300 bighas. I mean, come on. First of all, you did not need to make any change to this law. When you are changing, at least give some attention to detail. Now coming to, let's be a little serious now. Enough of fun and games. Have I finished my fun?
No, that's not.
That's the benefit of dealing with an act where there's little change. I felt I should give my time in parliament as I yield to my learned sister. She had lots to say on Bhanasur. Now coming to this very important thing, where they could have made changes. In 2000, when we went for, cut and paste is not only this government's or rather, this law department, law ministry continues. It's a continuum. And cut and paste has been always there. I'm not, attacking one particular government. It all babus in law ministry, the cut and paste is a mantra. Often we forget that cut and paste. Now, one of the criticisms of the penal code was Victorian. Like 377, they argued that the Victorian laws have gone and you have cut and paste and put your Victorian laws have not been changed. Now here what we did was, even when we brought the amendment, the Victorian country has done away with the law. For example, the example I was giving is the Civil Evidence Act of the UK of 1968, which had the equivalent of section 65B of the Evidence Act, right? Now that was deleted in 1999. And yet in 2000, when we brought in this amendment to the Evidence Act, we put 65B. Which the Indian Supreme Court in Arjun Pandit Rao Khotkar's case This is Ram Subramanian, I think, is the author, 2027 SCC 1. He says this is a poor reproduction. And you know, as practicing lawyers, some law students, there is so much of dispute on this law of 65B. When do you give it? Do you have to give it? Is it there in arbitration? Do you have to file an affidavit with the original evidence, primary evidence or secondary evidence? And when we included this, it was already removed. And yet, on absolute non-application of mind, 65B has been faithfully reproduced word to word, chapter to chapter, comma to comma in this Bharatiya Sakshya Adhiniyam. Whereas law has gone further and said in UK, which you had cut and paste earlier, that why don't you have a presumption that all emails, all these electronic documents are presumed to be validly sent. Whoever disputes it, you have a right to prove that no, this is actually a tinkered email or this is actually a manufactured document and that actually it is not so. So where you had an opportunity to amend the law, another place I would say, I think Mrinal will know better. Is there any provision on vulnerable witness evidence in this? I don't think so. Something where they actually could have dealt with how to deal with recording or have a special regime for recording of evidence of vulnerable witnesses? Zero. Nothing. So therefore, since I have time, let me end with a small story which has nothing to do with this, but I'm just filling time. This reminds me of, I don't think anyone has, and I must thank Shraddha for this. I think I'm the only one who's actually sat through these illustrations and seen the ridiculousness of these illustrations. But I only did it, I'm not that jobless. Otherwise, people will think I'm jobless. I want all of you to also check the illustrations in the penal code, this Bharatiya Nyaya Samhita. I'm sure it's the same thing. Someone should do this exercise for the penal code also. So, I want to end by, saying what this exercise is like. This exercise reminds me of a long time back in Florence, Firenze, when Michelangelo, the great master, had invited the mayor of Florence to inaugurate or unveil the great statue of David. Many of you must have heard of the statue of David, right? It's a beauty. So when the mayor unveiled the statue of David, everyone clapped, everyone was in awe of the statue of David. The mayor looked very suspicious or disapprovingly. So Michelangelo understood in a minute that there's a problem. He said, "Lord Mayor, please be frank. What is the problem?" And the mayor said, "The nose is a little long." So Michelangelo's apprentice was outraged. That's a work of beauty, but the mayor is saying the nose is long. So Michelangelo whispered to him, said, "Get some stone dust." So get some stone dust. So the apprentice went and gave him some stone dust. Michelangelo hid the stone dust in his palm and he said, "I will address this instantly." And he went up and he pretended to chip the nose of the statue of David and let his hand slowly take out the stone dust. The stone dust fell. He did nothing. He changed nothing. And he came back and asked the mayor, "Lord Mayor, now is it fine?" He said, "Perfecto, perfecto, perfecto." So this whole, I'd end by saying this whole exercise is the exercise of changing the nose size of the statue of David. Thank you.
Thank you, sir, for your eagle-eyed observations, which I'm sure all of us missed. And at the same time, for your absolutely critical analysis of the changes in the rules of evidence. So with that, we come to an end of our panel presentations and move on to the question and answer sessions. But before I open up to the audience, I am going to misuse my position as the moderator to ask a couple of questions myself, although hopefully that will give all of you some time to warm up and come up with your questions as well. So actually, Sanjoy sir has somewhat preempted the first question that I wanted to ask, but perhaps it is still necessary to be stressed a little bit, given the confusion, the retraining, reorienting, restructuring that these new laws will necessarily require. My very utilitarian question to the panel is, were these new laws really necessary, and could these changes, the ones that were useful at least, not simply have been achieved through a simple amendment? And
Sure, I'm sorry, in my attempt to be humorous, I forgot one important point on evidence. And this is something which I want the panelists to come back on. And I'm also joining you in asking them the question. I found one curious thing in the Indians in this evidence law. They have removed territoriality, and I wonder why. Because now it's strange. The other two have territoriality, but the Sakshi Adhiniyam does not talk about where it will be applicable. So is it that the Indian Evidence Act will apply extraterritorially? Just have a look, and the panelists may come on this. I have no clue why they've done that.
Yeah, so perhaps we can start off with these questions, and then I have one more, which I'll come back to after maybe we've discussed this. Also, no problem. Also, Rebecca, ma'am, I wanted to ask, and I mean, this will hopefully come from your experience, but it's quite clear that the rights of the accused and the procedural safeguards that were available, to the extent that they were available, have been weakened significantly. Why isn't there more outrage against it? Why don't people care more about those changes?
So, lawyers are generally lazy people. And we just concentrate on something when we have to. So at the moment, actually, what is the area of biggest contestation in, say, my High Court is this repeals and savings provision. Yeah. And there are about 6 single benches. There's no unanimity amongst them either. If you were to read the repeals and savings provision, it's actually identical to the 73 repeals and saving, and they would have been the same problem then, except that doesn't make it better now. A case registered prior to 1/7/24, FIR registered, charge sheet filed, trial on, let's assume. I have moved for bail for the first time in the High Court after 1/7. So which of the two different judgments from different benches of the same court? Now, surely if you had gone through the 73 experience, you could have brought in more clarity in the savings clause. But coming back to your original question, I think lawyers, the legal community, they're still coming to terms with it. There are much of what we do relates to the older law still, and so I think what everybody's thinking is we'll learn this by and by. I don't think people have understood the extent of change and how much of relearning we need to do. I was at a seminar the other day, and a very important point was made. I thought it was quite important that, when you have just randomly shifted sections, 420 is no longer 420, 302 is no longer 302, but the contents are the same. He said the language of our people have changed, because people used to say, wo 420 hai, and now you can no longer say that. So you've taken away my language. And I thought it was an important point, because there must be some reason why you are bringing about change. I'm not going into the change versus reform bit, but just change. And if for the substantial part of the 3 acts, all you've done is amalgamate sections and change the placement of sections, other than causing us pain, what has it achieved, right? So that's a question which you've changed the title, you've amalgamated. So if you see the penal provisions, all the definition sections are now under one parent section. Now, however much, there are areas of the old law which we all oppose, but there was a way in which you led up to a particular provision. Criminal force led to assault, led to punishment for, there was this structuring which was neat, bold, highlighted, and even someone who was not a lawyer was capable of going through that in a logical manner. You put them all together, there is no intervening space, and you suddenly see a lot of print, and you can't make out the difference between criminal force and assault. So I think even when you look at it from a purely aesthetic point of view, it's it's not a job there's just very poor housekeeping which has been done. And I would criticize it even for that, because it is important to put provisions in bold. It is important that one leads to another. And there is a reason why that was done. It's all missing now. And because it's all missing now, this new generation which will read this law will have no sense of why you arrived at the last part of the section. And this is how it started. One led to another, to another, to another. So, sorry, this is a very long answer. I don't know why lawyers haven't reacted more. I think they should. I believe that there should be more protests when it comes to the chipping away of the rights of individuals. I am particularly disturbed by some of the provisions in the CRPC where those rights have been compromised. And I think this should lead to some kind of a pan-India. Yeah.
Anything?
Yeah, so I think it's also how it's been marketed. Because if you looked at the PIB, which had put out something, and Hindu kept carrying it, saying that because the 1973 CRPC didn't fit within the decolonization, so we kept reading that it's the 1898 CRPC that's being changed, not the 1973 CRPC. So I think to the public it was as if there's 1898 and 2023. There was no 1973.
Such a big overhaul in 73.
Yeah, there was nothing happened in 1973. But I think, again, going back to that zero FIR and all of these provisions that happened, what we hear now is that, you can sit in your house and file FIRs. Now there's BPRND put out a primer SOP on how it should be filed. And so I told my students, I'm teaching criminal procedure over the weekend, saying, it says you shall go to the website and file the online FIR. So I gave them a task saying, find the website. Right? There's no website. So you've not set up this website. There's some website, maybe Bangalore Police has its website, where one student said, yeah, Bangalore Police has a website, but most others don't. So for a common citizen, it's like, oh, it's now I can file FIR sitting at home. But it doesn't tell you that the police may decide to do a preliminary inquiry and not even register your FIR. The same provision on public servants is sitting in the FIR provision. So all of these things, I think, have made the public think it's something positive, because most people don't understand what's ended up happening. So it's good PR, as it always is, of these are good changes, and this is people who are saying things against it don't know what they're talking about. And I think the other thing on criminal procedure at the end of the day is when the changes have been made to the BNS, which now miraculously from 511 sections is down to 358, by just squishing everything together. I think maybe there are many others, but one thing that stands out to me is the offense of receiving stolen property, which was 411 of the IPC. 410 defined stolen property, 411 had the offense. Now the section is titled Stolen Property, 317. 317.1 is stolen property, 317.2 is receiving stolen property. That goes back to the requirement in charge that you call the offense what it's called. It's now called stolen property. Right? So it's not about receiving stolen property anymore. And yeah, going back to that SOP, I just pulled it out again just to see what it says on your point on the zero FIR. It says after zero FIR, if necessary, primary investigation, which is some new term now, may be done by the investigative officer of the same Guwahati police station, and then at some point it shall be called zero.
Yeah.
And then the zero then will be transferred to the other police station, which will give its new number. That's the SOP, right? Not saying when it will be transferred or anything of that sort. So I think some of these things, the nitty-gritties are all lost on most people who don't know what this is about. I think to the public, it's, I think friends and others who are not lawyers say, why is there a problem? There's these are all colonial laws. We will want to call our aircraft Vayuyan. So, and it's not Adhiniyam, it's something else. The third thing is a new insertion, and it's ironic that a South Indian aviation minister introduces it and says we have done it in the three criminal laws, which is why we'll now start doing it in other laws as well. I think so.
Yeah.
That's where we are in terms of the public not understanding.
Right. Thank you. Just one more question that I had before we go on. Which
Let's very quickly add. Look, it's the political discourse on this, right? It was only meant to say, okay, we have undertaken a large-scale decolonization. Nobody has the time or the interest to work out whether that is true or not true. So in that sense, and ultimately also it is difficult to get traction as a public issue on, I think, criminal law generally, because you are generally trying to make arguments that sound like why we should be nicer to people accused of offences, right? And that is not sellable. Right? That is not sellable. And unless you are the driver of that SUV in Rajendra Nagar, right? Unless that comes to bite you, you don't realize that these things, while you think these things will never come to bite you, right? And therefore you're, okay, these are things that happen to bad people, and it doesn't happen to us. And one fine day you're thrown in jail for driving an SUV in flooded waters, right? It's just,
Yeah, and actually related to that, my question was that what I noticed or jumped out at me was also a sort of proliferation of unnecessary new offenses, like mob lynching, for instance, which seems to me that or killing someone through whatever. And it seemed to me that the earlier 302 with a common object or something was more than enough to prosecute the same conduct. And then similarly, snatching, I think, doesn't actually add anything new. So I just wondered if any of you would want to weigh in on the proliferation of offenses and whether it, what the implications of that is and whether we should be concerned about it, even in principle.
I mean, only to say proliferation of vaguer offences. Right?
Yeah. And mob lynching leaving out religion.
Yeah.
As a ground.
Right.
And your new mens rea of purposely, forcefully, quickly and things like that. I think that's from conceptually the big issue.
To continue the mindlessness, of course, now I am digressing from evidence to Bharatiya Nyaya Samhita. You talk about offences against the body, right? And then you include terrorism over there. You define terrorism as everything, including bombing a building when there need not be any body. So, I mean, there is absolute lack of application of mind. And as someone said, it is more of selling that, see, I have made the offences of women and in the front. So, it's all packaging.
Women didn't necessarily ask for their offences to be put in front.
Yeah. Any other comments on that?
I just had a question rather on the point that Rebecca, you made on the complaint procedure now.
Yeah.
So what is the point of issuing process anymore?
Because you've already heard
you already called the person. So I think that entire framework is now...
Absolutely. Since you've already heard the accused, you've got that version. So I'm assuming it's only if he is so disbelievable will the magistrate be compelled to issue process.
Because the case law earlier said since the accused is not present, some of these things have... Now your accused is present. So
even judges are flummoxed because, for example, if the person comes on this notice, pre-summoning notice, he presents his case to an advocate, then discharges the advocate and goes, then what happens? You again have to serve him.
Correct. Also, I think somewhere practicality has been lost. In the course of a case, we have 50 magistrates who look at a case, who get periodically transferred. The magistrate who's taken cognizance is not necessarily the magistrate who will be issuing summons. Now, if you've heard the accused, is it limited to just hearing from the hearer, or are you going to keep a record of it? Otherwise, this whole process seems to, of course, you have timelines now, which I said will be followed in breach, but this whole process seems to be a little disconnected. Why should you introduce an accused at a stage where he's not required to be introduced? Because if the the answer was given by a senior sessions judge to me. What was his answer? Was that, we get so many false cases, brother, sister fighting with each other, all of that. If we have a version beforehand, it will help us. So my answer to that is, when we challenge summoning orders, it's not because the case is weak, but if we're challenging your non-application of mind, it's not going to improve because you've heard the accused before you've heard the complainant. So I think this procedure will only add to chaos. It's not going to help because an accused is not meant to be there at that stage.
Yeah, so anyone from the audience now, if you have questions, please raise your hands. You can turn on your mic, introduce yourselves, and go ahead and ask your question. Yeah.
A very good evening. So this is Rahul. I'm from iPro Bono. So, ma'am, this question is to Ms. Vivaka, ma'am. Ma'am, I certainly impressed by the overlapping between the, like when you said zero FAR and then you have a preliminary inquiry. So then I extended the same with the section 183 where the recording of the statement. So it says that any magistrate of district in which the information about commission of any offence has been registered may, whether or not he has the jurisdiction, can record the statements as goes. So I'm wondering, is it like a zero FAR can make the recording of statement of any magistrate?
Yes, I'm so grateful you said. I should have said that earlier. The 164 statement can be recorded by a magistrate outside the jurisdiction of the offence. All of that can take place.
And what about remand and bail?
Of course, if you are arrested,
Correct.
then remand.
And then after all this for trial, it will go to the jurisdictional court.
The problem is even the earlier 167 also talked of a magistrate who has or does not have jurisdiction. So that concept was there because, you know, a person can be arrested in Bangalore and brought to Delhi. There's a concept of transit remand. So you don't necessarily have to be a magistrate of jurisdiction. That is not the problem. The problem is at what point do you transfer the zero FIR to the police station of jurisdiction, because this is, to the best of my understanding, the call for a zero FIR was made because a lot of complainants were being thrown from one police station to another. So, okay, you've given it to them. But then ultimately it has to be, there is a concept of jurisdiction. It has to go to the police station of jurisdiction. The code is silent, or whatever it's called, is silent on when it goes. And because it's silent, I think there is potential for misuse because a place without jurisdiction, the police officer without jurisdiction can end up doing a lot of things which he would otherwise not be allowed to do.
Ma'am, I certainly feel that there is a confusion and overhaul may happen after that. So that is why I asked the question. Secondly, I also had with respect to handcuffing. Yeah. So handcuffing, we forgot to speak about. But ma'am, the section contains anything under the criminal laws, like the police, throughout the thing, what I feel is the civil liberties has been curtailed. The police person has given the discretion of deciding the offences, and with respect to handcuffing also, I certainly feel that the police person can decide whether he can handcuff or not, and certainly they will do. So the definition of handcuffing, when they can do, contains everything because of the vagueness of the offence definitions, I think.
And it's contrary to Supreme Court law.
Yes. So those are it.
I certainly think there's a project to be done of how many of these changes are contrary to existing case law, right? In terms of just across these various provisions. I think there's work to be done on that, just to map it, right?
Yeah, any other? Yeah.
Hello, my name is Dr. Nidhi Mens. I'm an assistant professor in Faculty of Law, University of Delhi. So my question is to Dr. Anup. Actually, the principle of criminal law demands that a prudent legislature, when is making a conduct a crime, has to take into account considerations whether the law which is seeking to criminalize is socially useful or at least neutral in its effect, so that it doesn't allow people to do something which they are not supposed to do. For example, what Shraddha just pointed out, we have seen criminalization of ordinary conducts like consumption of beef under the cattle laws and the resultant evil associated with it, that is the mob lynching. So sir, because I personally believe that it's the cattle laws by the state which actually breeds hate crimes and brings intolerance. So now we have seen that the state has now to tackle mob lynching, has sought to criminalize it with heavier punishment, that is death penalty. So what are your views on it, sir? So would you say that it's a phenomena of over-criminalization? Thank you.
Yeah. No, the point I was trying to make was that it's more a problem of constitutional law that it does not have an answer to this question.
Yeah,
right?
because the cattle laws are not declared unconstitutional.
Exactly. But even when like when Maharashtra is looking at the anti-beef law, that it's looking at possession, it is not asking it from a what are the constitutional limits on criminalization, right? Or even if you say criminalization of triple talaq, right? What principle constitutionally? What are the principles? Should constitutional law even get into it, right? Of asking the legislature, could you have criminalized this, right? And I don't think there's an answer really on that question. We find different ways to get around this question of can you criminalize, not criminalize, and it is never a straightforward question on that this action should not have been criminalized. And I think it gets into tricky questions of judicial review and limits of judicial review, whether a court really should judicially review a legislative decision to criminalize, right? I think courts are far more comfortable getting into questions of proportionality of punishment. Is the definition clear enough? All of those things are better. I'm not saying it's that jurisprudence is fine, but I can see courts being very reluctant about if the legislature decides to criminalize something. On mob lynching, I mean, and death penalty as a punishment, look, there's a larger, I mean, obviously it is not going to work, and it never works in terms of this thing that higher punishments will lead to lesser offenses of that kind. That logic just doesn't work. But in terms of look, the fundamental problem is we seek to solve social problems through criminalization, right? What are complex social, economic, cultural problems are then sought to be solved with the blunt instrument of criminal law. And criminal law is just not equipped or suited to deliver those results to you. Right? So, criminalizing anything is not going to solve that social problem.
Yeah, it should be used as a last resort.
Yes, and it very often is used as the first resort. Right? Yeah.
And just to add to that, to the very limited extent that our courts have dealt with questions of criminalization or decriminalization, it's been shoehorned into the fundamental rights question, which is a very limited question to begin with. So it makes it very difficult to actually do any justice to this. Yeah. Any other questions? Yeah. Okay, turn the mic on. Yeah.
Dr. Mrinal Satish. So, has this law in any way impacted sentencing guidelines? Have they brought in anything to guide courts?
I would say fortunately not. And like Anup said, you see much more mandatory minimums coming in, which is a problem. The one thing, again, going back to Macaulay and the Indian Penal Code, except when amendments were made, and I think there was a philosophy, whatever the philosophy may have been, in the manner in which punishments were. You don't actually see an articulation of what the philosophy is, which is a problem with the IPC. But like, say, if you look at the sections on mischief, like Anup said, there was a proportionate punishment increasing. Again, you could critique it, saying that what was valued at that point of time got higher punishments, and offense against the body, similar thing, had lower punishment, but there was a philosophy. I think here it's just what I feel like at this point, 10, 20, 25 life without parole and things like that. So I don't think there's too much thought that's gone into that, and that's where I said justice being thought of, and going back to Shraddha's question, justice being thought of as victim centric, and so that victims will be happy with higher punishments, and sort of packaging this law as, I think, justice to victims, when in fact it's absolutely not, because you put more barriers to victims reporting it, or like Sanjoy was saying, you have nothing about how vulnerable witnesses would testify or anything of that sort. Nothing, no change that way on guidelines and whatever, which I think is good. There's no mess created in that.
Just on the death penalty, I think I mean, these things are about small movements of the needle in that sense, and I thought it was quite encouraging for those of us who work on the issue that this the Parliamentary Standing Committee sent back a recommendation saying that there are concerns about how the death penalty is being used, administered, but we leave it to your discretion, right? So there was no ringing endorsement of the death penalty, and there is a acknowledgement of the issues, which is something to take note of. That sense is there, right? It may not amount to much in terms of practical outcomes, but yeah.
Yeah.
So my question is a little broader one, which is with respect to this government has been bringing in bills after bills, acts after acts. This is the criminal law is one example, the broadcasting bill. So the quality of the laws has been comparatively very poor compared to other countries which have been bringing in these laws. So is there any experience from other countries that we can borrow? Because frankly, the first iteration of this law, when I saw, seemed like it was done overnight and put in the public domain for the public to answer, like what is to be done with it. So is there any experience that we can borrow from or go about how improving these laws in the future when they're drafted?
Okay, on the criminal law, this is where Mrinal also can speak to it. Both the IPC and the Evidence Act has traveled the world, right? In that sense, it's not because of its colonial origins. It's there in countries in Africa, in Southeast Asia, right? And there is a reason why many of those countries have not done what we have done, right? Not like they didn't want to bring it more in tune with contemporary realities, and they have not chosen what we have done, right? And so it's not just some unique Indian issue that, okay, we are stuck with a law made in 1860 or 1872 or whatever it is. But there is a thing of, and as both Sanjoy and Rebecca were saying, just the complexity of this exercise of creating this, right? And there's a logic. It's difficult to just uproot it and create something new, right? And you haven't, and what you've created, that complexity of conceptual flow, how do they interact within the legislation and between these three legislations are all very, it was a balance that was a very delicate balance, and that has been significantly disturbed, right? So from that experience, I would say sort of that comparative experience, it would have been worthwhile reflecting on why other jurisdictions haven't undertaken or even professed to undertake some massive overhaul. Yeah,
I think in terms of the overall of the IPC and the Evidence Act, especially the Singapore did something a few decade back. Again, not overhauling, but changing parts of it after a long process of working with lawyers, academics, courts, everyone together. I think for me, again, I don't know the answer to what other countries are doing, but I think it also goes back to parliamentary, what's the word I'm looking, parliamentary control over legislation. Because even if you look at 2013, there were mistakes, there were errors in that law. There were typographical errors in that law. And when some members of parliament stood up to point that out, if you listen to the debates, you see the transcript of the debates, they were told this is for women, so sit down. Right? So the errors were then legislated. And so I think for the last 20 odd years, and this is again goes back to because the criminal law CRPC that was amended in 2005, 2006, 2009, all of those amendments have typographical errors here and there. And there's no debate, because I very distinctly remember 2009 when the debate was happening. I switched on to see what was happening. The thing that I remember is there was something happening about A.R. Antule. So the opposition was screaming slogans against A.R. Antule, and the speaker was going on saying those who say I and whatever. It was just things getting passed without even anyone looking at it. So I think that's where in the last 20 odd years we have failed, because both parliamentary standing committees or members of parliament, who even people who have wanted to suggest changes to it, nobody has heard this. So I think a parliamentary process is a problem in the last 20 odd years, that nobody has paid attention to these laws, because I'm like Sanjay was saying, the drafters have been the same for the last 70 odd years. So you've had people cutting and pasting things coming into parliament, changes happening in parliament, which has stopped.
But Mrinal, just also keep in mind the elephant in the room. This law was thrust when 150 members of parliament were suspended. Also, I don't know how many of you know that this is a second draft. The first draft was so atrocious, with so many spelling mistakes, sentences left midway, that though it was referred as a face saver to the standing committee, it didn't come back, because if it came back, then they would have to say each clause amendment by amendment and expose their incompetence. So they actually jettisoned the cabinet withdrew that bill. And this is the 2023 criminal law number 2, which was thereafter passed.
1 second. There's a question here. Yeah.
So I have 2 questions actually.
Can you speak in a minute?
One was on...
What's your name?
I'm Sridhar, as I've been introduced as the husband of Shraddha, but I had 2 questions actually, perhaps ma'am could answer them. One is in the new section 61, which defines conspiracy and also the punishment. There is an introduction of the words common object, which it's not there earlier.
Yeah.
I was wondering whether you see that changing the way in section 61 120B is litigated now in court. That was one. And the second thing is something that Dr. Satish and Anup also spoke about, is section 69, which is deceitful means. The explanation for what a deceitful means will include is an inclusive definition. And it says, shall include inducement for or false promise of employment or promotion or marrying by suppressing identity. So it's not only these 3 things. So how much do you see this definition being expanded? Because in terms of sexual interactions, there may be several deceitful statements that are made which may or may not induce somebody. So how do you see courts reacting to this kind of a definition?
So, the introduction of common object, and this I'm saying only through my personal experience, I think is largely to do with the wholesale use of 149 and those provisions in cases today. So if you have 4 or 5 or more people, it is imposed regardless of the checks and balances that are there in judgments. And we saw the use of 149 to the extent it has been used. I've never seen it before in the prosecution of the Delhi riot cases. I think this has been, and because there was some kind of pushback in the way we argued those matters by saying that everybody, and a lot of judgments came out which said everybody who was part of that assembly cannot be prosecuted. I think this was deliberate, so that you get all of these sections available. You have 120B, you have 149, you have 34, wherever you can use it. Everything overlaps with the other, and it's your choice. So I think that's a disturbing introduction, because there were clear indicators as to what could be used when, and now everything is basically the same. As far as, what was the second question?
Deceitful means.
Yeah, you can answer that. Mrinal takes deceitful means.
Like I said earlier, the explanation is wide and can bring in that, which is where I was referring to the jurisprudence in the UK and the US, which have gone into the question like on stelding, and said whether that amounts to conditional consent and deceitful means, and said yes in the context of stelding, saying the understanding there was that the man would be using a condom, which but in cases where the deceit is about whether the man is sterilized or not, their courts have said, but you agreed to to penetrate without a condom, so what difference does it make? So that's the concern with with this sort of section, we never had cases like that in India reported. So I don't know whether there's anything of that will get reported. But that sort of problematic jurisprudence that already exists can very easily come in with this sort of explanation that we have to the section. So conceptually, to me, the section makes absolutely no sense. Because the case law also on breach of promise to marry had gone into 90, done all sorts of things at that point of time, but very clearly at least articulated that at the time of intercourse, there should have been there's been no intention to continue to get married to the woman at all, in which case it is rape. So whether you needed breach of promise to marry to be brought in and rape to be said not amounting to rape and reducing punishment, I think that creates a conceptual question.
Even in the jurisprudence that has developed over the last few years over this false promise to marry, you could sense a certain uneasiness because, a lot of these cases came with bulky records where messages were being exchanged and, it was normal activity between a couple. And then suddenly you say that there was a promise to marry. So there was a certain degree of uneasiness while dealing with these provisions, and some of it is articulated. And now you have it as a provision which says it is not rape. It's all very confusing. So I actually feel it does disservice to women to put it within a section of offences against women, because it completely takes away agency from a woman, and it says that it puts marriage at a premium, as though that's the only thing you can aspire for. And if you fail to marry, then it doesn't take into, as I said,
there's promotion also.
Yes, there's promotion, the employment, promotion, all of it.
No, but you see, I have a fundamental problem with 69. If you see, 69 is very inartfully drafted because it doesn't even contemplate the mental condition or the predisposition of the woman. So it says whoever by deceitful means. So it is deceitful means employed by the man. But what if the woman is aware that the man is taking deceitful means? So now this is left to case law and fact situation to deal with. My point is that when you're drafting, why don't you at least be artistic in your drafting? The word should have been whoever by deceitful means, vagara, 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 induces the woman to have sexual intercourse. So that is not there. So, for example, let us say a man says, I will give you a promotion. And the woman knows that the man can't give a promotion, but the man is being deceitful. Now, see that section 69 criminal law has to be interpreted strictly. That this is a conviction.
Well, if she knows, then it wouldn't be deceit, no?
Two.
I'm just saying this whole section is a bit crazy.
Sorry.
Yeah, go ahead.
No, I was just saying that the false promise to marry route had, as Mrinal was saying, 90 was a crucial component of that. 90 IPC was a crucial component. And one of those elements there has been deleted from 69, which is that, and if the person doing the act knows or has reason to believe that the consent was given in consequence of
that action,
fear, or that element has been removed from here, right? And therefore makes it a much easier offense in that sense to...
Yeah, but I think, again, I have a view that 90 should never have been used.
Yeah, that apart, yes.
I agree with you.
Uday, which was the state of Karnataka, which led to all of this. Because I think deceit means that, there's an intention to deceive means you're making someone do something that they would otherwise not have done, which is clearly conceptually rape. So there's no rape for any of them.
Their consent is vitiated in any case, so therefore it's rape.
So the contradiction here is not calling. It's absolutely.
Correct.
No. Okay, anyway, don't want to belabor. No, I was only saying that since it is whoever, now even if I have let's say I've misrepresented my identity and I have had sexual intercourse with a person, even subsequently, sort of just to make Sanjoy's point, I'm wondering what would happen if the person says, okay, it doesn't matter to me that you misrepresented this aspect of your identity, but yet that doesn't matter for section 69, right?
It doesn't.
It doesn't matter.
Also, for example, let's say someone has by deceit made a false ID card, saying I'm the managing director of this company. Let's say the woman knows that this is false. It doesn't matter. It doesn't matter. No, but his deceit is there, that he has entered into falsehood, he's made a false fake identity card. So my point is that when you're making a criminal law, please make it foolproof. That's all.
That's strict. Yeah.
It's also really interesting on this, the jurisprudence of false promise to marry. The research that's been done on it shows that the way the courts interpreted it also sort of forwarded caste norms and heteronormativity. Yeah, so it was very much like a believable promise to marry would only be one where you're of the same caste and a marriage is actually possible, same religion, all of that. So yeah, that jurisprudence was already very problematic, and now that's
a very problematic
correct
for a certain phrase.
Now now it's been sort of reified with its own section. So yeah, sorry, there was another question.
Hi everyone, I am Udit. I am a PhD candidate in NALSA. So I have a question with to Dr. Surendranath. You said regarding the mapping of the changes with the Supreme Court case laws, whether it is in consonance or against. But there's on the other hand, there's a trend, especially on life sentence till the remainder of the person's natural life, which is basically the judge Supreme Court made law after Sradhanand and then Sri Haran, and now it's being codified in the penal code. As far as I can see, it's in 11 of the provisions of this BNS. Regarding the remission policy, that's one issue. It restricts the remission powers of the states. On the other hand, the effect of this type of sentences, because now the higher courts are specifically commuting death sentences, giving the regions, say 20 years without remission, 25 years without remission, 30, 35, and so forth, so on and so forth. And they are saying reformation, rehabilitation is the purpose of this commutation. Now, if a prisoner is not going to be released, that's another thing that they're not restricting the governor's or president's power under this act, which Sri Haran specifically says. How do you see these sentences, where the advocacy against the death sentences is going on, and now the courts are commuting these death sentences on this thing? And this is basically, it goes opposite. The court created a sentence and now it's been codified in the law itself.
No, I mean, I'm sort of very clear on that. It's no victory for those of us who advocate against the death penalty, that we are getting longer and longer sentences without remission. It is a sort of Pyrrhic victory, really, right? That when you get these sentences, and I think judges are the fall in the confirmation rate of death sentences is unfortunately on the back of such sentences. So absolutely agree with you that qualitatively there's no difference between the death, or in terms of the cruelty of the punishment, there is no difference between the death sentence and asking somebody, and some of these cases have also said rest of natural life, no release, right? So I don't make any qualitative difference between the two on those two.
One second, in case someone has a new question, or do you have a follow-up?
No, a new question.
So then,
Give him no for thing. Allow him.
sir, one. Yeah.
I'm Devanani, I'm an advocate on record. My question is, I think Dr. Anup had spoken about section 106 of the Bharatiya Act, that if somebody causes death by rash and negligent driving and does not report it, then he will be punished for 10 years. So this is clearly, it is forcing the person to appear ruthless against himself, and is also contrary to Article 20 of the Constitution.
Good point.
So how do we see this, the interplay between the constitutional provisions and these provisions of the new act which are violated? How do we see those panning out? Maybe the courts will settle the, but then generally what do you think about it?
So I wonder, as a counter to that, somebody has caused death of a person by rash and negligent driving, so there's no dispute as to that, but has reported. Does the sentence get reduced then?
The Good Samaritan law, like a forced Good Samaritan law, that if you report it, you will be like.
No, but you know, this addition of the word does not report in subsection 2, which makes it punishable, which may extend to 10 years. Suppose one of the two ingredients are fulfilled, what happens? I mean, again, what Sanjoy was saying, law has to be clear, and So clearly, reporting gets you brownie points, but not reporting will get you this sentence. But what if you report? It's unclear whether you can escape with. I mean, although the description is of a term which may extend to 10 years, so there is some discretion with the court. So I guess the fact that you reported may just earn you a better sentence.
I would think that the way I would read it is that if you report it, you won't be proceeded under 1062, you will be proceeded under 1061.
Yes.
Right?
Yeah.
And
you've kind of cooked your
under one. Yes, I agree with you. Right? You have implicated yourself in 1061. I agree with that. Right? Yeah.
One more question. Anyone? Yeah,
notified yet strange.
My name is Fahad. I'm a faculty associate at BML Munjal University. My question relates to, it's a follow-up on constitutional law only, and the exceptionalism which is now being mainstreamed in the procedure. So Professor Surendranath has pointed out how there's a missing link in constitutional law in terms of criminalization. But how do you think, given the background of Indian constitutional law's response to exceptionalism, can we expect a response, where settled criminal jurisprudence relating to procedure, say remand, which is now going to affect bail, or say ex parte trial, which may be a violation of natural justice? So how do you see that this exceptionalism will now be settled in the court?
Yeah, look, I'm not too hopeful, right? If you look at the court's decisions on TADA, POTA, AFSPA, right, all the constitutionality challenges on all of these, when extraordinary measures were under challenge, and the kind of judicial deference that is on display in these decisions, I'm not hopeful at all, right, in terms of how the court is looking at this. I'm very curious, and I think this is something, and I'm so glad Rebecca mentioned the police remand point. This is something that we've been harping on since the first version of the bill came, and I think it is a reading that very, very few people are really engaging with in terms of whether you have effectively, by mistake or not, you have now opened up the door for 60 or 90 days of actual police custody. If a constitutional challenge went on that issue, I'm still not sure that the court will, because the court is operating under sorry to put on my constitutional law hat here, right, that when questions of law and order and national security are in play in constitutional adjudication, the court seems to be very reluctant to sort of have too much judicial scrutiny of it, right? And if you try and look at when has the court really struck down, even when it has struck down criminal law provisions, what sort of criminal law provisions has it struck down, right? It's interesting to look at. I mean, you can think of 303, adultery. Where is it finding its voice? In what sort of context? And this is not to say that it hasn't found its voice in a lot of those judgments on torture or legal aid or whatever. But that's more in the nature of sort of asking the state to be a certain way.
Mandate.
Sort of. But in actual striking down, right, it is quite deferential, I would think. I don't know. I mean, I might be overstepping making too broad a claim, and I'm trying to recollect as I say these things, if I can be contradicted and which judgment can be cited to. I agree. Yeah.
Just to add, I think there's something that I've written about. When there's a constitutional or criminal law interface, the court has said that if prejudice is not caused, it's perfectly fine. Right, so it'll come down to whether, on a case-by-case basis, whether prejudice is caused or not, because the standard that's been set up is saying if in the objective of finding out the truth, whatever that may be, if prejudice is not caused to the accused because you violated a process, then it's perfectly...
see, if you should be given more custody or not is a case-by-case determination.
Actually, the whole concept of increasing the time frame when the 15-day period was something which was nudged by the court in various decisions, saying these people go to hospitals and they don't effectively give time for the police to investigate. So the whole the jurisprudence is centered around the correctness of the police version and their need to come to arrive at the truth, and the fact that the first 15 days can be wasted. So this suggestion of extending the overall period to 40 or 60 days, assuming that's all we have to deal with, also is a suggestion which has come from a court.
Yeah. And
sorry, go ahead. No.
Look, I think it's very worrying that increasing number of judges, including chief justices, have said that there are too many rights for the accused. Right? There are too many rights for the accused. It is seen as a zero-sum game between rights of the accused and rights of the victim. Right? And there is such a patently disingenuous approach for judges to take, that somehow you will better the cause of victims by reducing the rights of the accused. And that is the paradigm in which the courts seem to be operating. And it is not a zero-sum game. It is just as difficult for victims and survivors of crime to pursue justice in this country, right? And there is no difficulty with, and it's obvious to everyone. At the same time, custodial torture, manipulation of evidence, wrongful prosecution, wrongful conviction are also realities of the criminal justice system. So it is not that if you bring down one will improve. They both are very separate problems requiring separate solutions. To say that we will improve the life of victims by making the lives of accused worse is no real argument. And it's really dispiriting when and chief justices say this. Okay, I mean, I'm not saying which chief justice, but okay, it's just and it just makes no sense, right? It's okay for a politician to say it. I think it's okay, but when judges start peddling this, right? It's
I think just to add on case law, there again a mishmash of provisions. If you look at section 175(3), which used to be 156(3) of the now of the CRCC, 175 of the BNSS, it talks about an affidavit to be given while filing what
it was part of that.
Part of case law, right? And then this is very strange because it's talking about an affidavit in a previous section which does not talk about an affidavit, right? So if you were to look at it and say, wait, what are you talking about? Because the previous section is not talking about an affidavit, but that comes from court saying there should be an affidavit along with the 156(3), which was never there until that case, I can't recollect the name, came in.
Yeah. Priyanka Shivas Chaturvedi.
They were given a tough list.
Peter, did you have a question? Or?
No, maybe others could ask him.
I had a question for Ma'am. I think there's a question there at the back. The person who's not asked.
Oh, Junaid.
Hi, I'm Junaid. I'm a PhD candidate at BML University. I have a small question to Sanjay and to others. We have seen in the name of decolonization where we have gone, and now other laws are going the same speed. Where will this end up? And what measures should we take at local or federal level? Different ideas have been put up to fight the same.
In fact, let me tell you, yesterday Justice Narasimha, I think, has done an amazing thing, and this is the first thing which has happened in the Supreme Court and is, I think, revolutionary. A bench presided by him yesterday has said that there has to be a legislative audit of that Maharashtra legislation. So it's time we start this concept of legislative audit to see we are enacting laws after laws. You have this 2008 Street Vendors Act, so Food Security Act. In the previous UPA dispensation, there will be laws by the dozen made. It's not that this government is the only government which is doing that. But the point is that we have never ever seen how these laws have worked. So it's time to have legislative audit. I think that's a very, very good idea. The Supreme Court has taken a revolutionary decision in this. It has asked the Chief Secretary to do a legislative audit and report to the Supreme Court on how this law has worked out. And there are many legislation, such as the domestic violence law, such as the SC/ST Act, such as so many legislation which actually need this kind of audit.
I agree. So actually, I think did you want?
No, I was saying decolonization. I mean, you saw just before. I assume for the moment that conversation is buried for now on decolonizing the constitution itself, right? And there are books written on it. So
Bestsellers.
so look, there is a difference between we can have a thick engagement with what does it mean to decolonize. This sort of very silly understanding that it is that colonial means only what was legislated during colonial times just makes no sense, right? Why is this? Why do we call the IPC or the Evidence Act colonial? Has to have a deeper version of what is colonial, right? It envisages a certain relationship between the state and the citizen or the people, where the people are seen as a threat to the state, right? In that sense, that's a relationship. A colonial government views its own people, or the people that it's governing, as a threat to its own existence, and therefore then criminal law is used in that project. And if we were to really seriously have a conversation about decolonizing, it is changing that fundamental relationship and that framework of relationship between the state and its people, right? And these criminal laws, for a variety of reasons that have been discussed here today, only further that colonial logic, that the people are viewed as people who need to be controlled, curbed, you need to have higher punishments, all of that further exaggerates that colonial relationship between government and people. And you are treated as a subject. Right?
In fact, So in fact, this so-called colonial legislation, and since I was dealing with evidence, you see it actually said confession to a police is inadmissible. So even in those days, the colonial state was protecting the citizen against the police.
Which has, please, Elizabeth Kolsky has great work on why even that provision has very racist undertones to it, right? But you're right. Yeah. But you can see that even the colonial state says confessions to a police officer are inadmissible, but an apparently non-colonial state in so many legislations has attempted to make confessions to a police officer admissible, right? And
Not attempted, it's
happened. It's sort of
On a slightly different topic, I think this overemphasis of everything being videographed. I have great. I genuinely believe statements should be written by the pen on a paper, which an accused doesn't have to sign, because I think what people don't understand is that a camera can hide many things, and it gives it a certain sanction. Oh, it's videographed. We've seen the man in custody smiling at us. It is not. It completely changes the narrative as though something perfect has been presented. So I think I think sometimes we just refuse to engage with reality, and judges, lawyers, all stakeholders, and these particular laws actually tell us how not to engage with reality. We videographed everything. It's all audio videographed. It's perfect. This strive to attain perfection actually is a problem, because that videography does not tell you the true picture. You're not seeing the men with guns standing in front of you because the camera is ahead of them. So all of this actually adds to the problem, because you have very simple answers to misuse, and you believe that those answers are perfect.
The point which Rebecca made at the start of this program is very important. As lawyers, when we cross-examine witnesses, the demeanor for us and the demeanor for the judge to note is most important, and it cannot be done videographically. It just cannot be done. The judge can't see, you can't see. And that is so important.
You can't hear. What are you talking about? You are a country of very poor people. This technology, this thing, everything will be audio videographed. Where? I have had occasion to go to courts in Uttar Pradesh. in 2015 and 16, where they were using manuals without the Criminal Law Amendment Act of 2013. It was news to them that it had been amended. So what are you talking about? Is all of this the same, which will apply across this country? I don't know. I mean, we can barely there are many times when we argue virtually, even today, when court says we can't hear a thing of what you're saying, and you want entire trials to take place in that situation. It's crazy.
And they are not debating the value of oral hearings, which
Not
have
at
their
all.
own virtue.
Yeah.
Especially
I mean, even arguments are telling you. Anushka is here. She was with me in a matter yesterday. I was forced to do it virtually because there were so many clashing matters. There was a matter in the Supreme Court which I should never have lost. But I told her I wish I was there physically. There is a difference, even when you are conducting arguments, there's a difference. You are able to push through things when you're there physically. It's over before you know when you're there virtually. You're at a tremendous disadvantage. So I think this whole concept also needs to be reworked and reassessed. How good is it? It's all right for mandatory hearings, it doesn't matter. But when it comes to the crux of a criminal trial, you have to attach importance to the physical presence of people.
And I think the solution that they have found to technology is you can use your mobile phone.
Yeah.
And the search provision says that the IO will use the mobile phone and convey it to the magistrate, I presume, over WhatsApp. Is there nothing else? Probably. But then that also goes to the thing of it's now so easily available on the IO's mobile phone to leak.
Privacy issues.
Right, so to the press to watch on TV the next day that there was a confession made by this
Confession
person.
recording is made optional, whereas this is mandatory. I don't, you don't understand the logic behind what they've done.
So your 65B going to now, is it secure, not secure, whose phone, which phone, how is it being conveyed, all of that.
I think we are now unfortunately out of time and must wrap this up. I think we've had a riveting discussion and we've gone through crucial issues of vagueness of the new offences or existing offences which were not addressed. We've talked about enhanced punishments, removal of safeguards, weakening of rights, all really critical issues. And I think Sanjay sir's eagle-eyed observations of the Saksha Adhiniyam have told us something really important, which is that this decolonization exercise, even in the token of language, has been really half-hearted, it's been piecemeal, and has lacked the kind of clarity and attention that it should have got, that it deserved. So hopefully everyone has enjoyed this and learned from this as much as I have. Thank you so much to all our panelists. I now invite Fahad to very quickly give a vote of thanks before we head for refreshments.
Thank you everyone for a truly vibrant discussion. Thank you to everyone present here and everybody joining us online. First and foremost, I would like to express our sincere gratitude to our esteemed panelists for sharing their valuable insights and expertise with us. Your knowledge and perspective have enriched our understanding on the changes that lie ahead, as well as the many challenges and the chaos that we are in. We are immensely grateful to the Vice Chancellor and the President at BML Munjal University for their unwavering support and encouragement. Their guidance has been instrumental in creating a conducive environment for intellectual discourse and academic excellence. I would also like to extend our heartfelt thanks to the Dean, Professor Preetham Barua at School of Law, for his excellent leadership and constant support. We are grateful to our colleagues at the School of Law for their tireless efforts in organizing this event. Professor Shraddha Chaudhary, as well as Professor Surbhi, who is not here right now, has been truly instrumental in... Thanks. I would also like to acknowledge the support of many teams within the university, communications team, IT team, for their constant help throughout in organizing this. Further, our collaboration with the India International Center and Live Law for the support that they are providing here. And finally, I would like to thank each one of you who are present here physically in the audience who asked the questions. Thank you. We'll follow up with a small token of gratitude for our panelists, after which we'll invite everyone to join us for the high tea outside. May I gratitude to Professor Mrinal Satish. May I request Tanmay to please hand over a moment of gratitude to Professor Surendranath. May I request again Karthik to please hand over a moment of gratitude to Ms. Rebecca John. Finally, I invite Junaid to please hand over a moment of gratitude to Mr. Sanjoy Ghose. Thank you, everyone. Please join us for conversations over the high tea. Thank you.